If you have received a final notice, notice of intent to levy from the IRS, you need to take action. Your property and your rights are at risk. You must not wait. The plain truth is you should never ignore any IRS notice. We at Britton Associates would be happy to explain to you in detail all of the possible consequences and your legal options if you have received a final notice, notice of intent to levy.
The final notice of intent to levy is the formal notice by the IRS that it intends to seize your assets. It is also your notice of a right to a due process collection hearing. Often, the IRS uses it as a means to get your attention. The IRS notice of intent to levy gives you three key things. First, it gives you the date of the notice, which also sets the deadline when you must file an appeal for a collections due process hearing. That deadline is 30 days from the date of the notice. Second, the notice gives you the name and address of the IRS officer with whom you must file this appeal for a CDP hearing. Finally, the notice gives you the type of tax, the amount of tax, and any penalties associated for this levy. If you fail to respond, the IRS can seize your assets. It can seize your bank accounts. It can seize your wages. It can seize your Social Security payments. It can seize your tax refunds. It can seize virtually any asset that is not secured by other security interest. In short, the IRS can make your life miserable. What can you do? Usually you have four options. The first of one is the request for the collections due process hearing. Second is you can propose an installment agreement, either a full payment installment agreement or a partial payment installment agreement. You can propose an installment agreement independently or as a collection alternative under a collection due process hearing. Third, you can make an offer in compromise, one of the three types, including one of the two types of payments. You can do an offer in compromise either independently or as a part of your due process collection hearing request. Finally, in certain circumstances, you may consider bankruptcy. Can you represent yourself? Sure you can. But should you? No. Over 35 years of practice, I've represented hundreds of taxpayers before the IRS, including several attorneys. An IRS appeal is complex, difficult, and risky. Get help. Every year, I'm forced to give one or two taxpayers the bad news that they have lost their best opportunity to resolve their tax debt with the IRS by failing to respond to the final notice of intent to levy. If you do not respond, you lose your right to a hearing or a review by the tax court. If you receive an IRS final notice of intent to levy along with your notice of right to due process collection hearing, your rights and your assets are in jeopardy. You are at risk. You should never ignore any IRS notice, but particularly not a final notice of intent to levy with notice of your rights to a due process hearing. Contact us. We can help. www.britanda.com.
If you receive a final notice of intent to levy from the IRS, your assets and your income are in jeopardy. You are at risk. You should not ignore any IRS notice, particularly a final notice of intent to levy. But you do have options. Contact a qualified professional for help.